I'm live. Yay. So I've been looking forward to watching this particular hearing. This is the Bradl hearing. And I've had a bit of spoilers. I hope no one spoils it too much more for me. I do know how it ends. And so because I know how it ends, obviously, I know how it ends. But I still want to watch it. I haven't watched it, so I don't know like what all the interactions are. So we're going to watch this. I might have something to say. I might not have something to say. I don't know because I haven't watched it. But we'll see. We'll see how it goes. So if you're watching this on a later replay, I apologize. I will be playing this at 1.5 times speed because I am on a timer. And hello to you too, News Now Houston. Don't know the story? Well, I'm sure someone will love to fill you in on it because this is drama crack for the Discord. So let's, without further ado, let's get into it. Well, this is exciting. I just went to where I saw in this video to where I saw the Zoom call up. So the Zoom call is now up. It looks like it starts.
Thank you very much, officer. Thank you, everyone. And good afternoon, Mr. Clark.
Good afternoon, Your Honor. This is 23 CR 313.
Now we got a new judge.
Can I have counsel identify themselves starting with the Commonwealth?
Good afternoon, Your Honor. Kenneth Mello, Commonwealth.
Special Prosecutor Mello, welcome.
Thank you, Your Honor.
Good afternoon, Your Honor. Timothy Bradl on behalf of Aiden Carney.
Mr. Bradl, welcome. Is it Kearney?
Carney.
Carney.
Like the honeymooners. Art Carney.
Mr. Carney, can you hear everybody, sir?
Again.
All right. Let me briefly see counsel at sidebar.
Just so everybody's aware, a sidebar is where the judge is going to give the attorney's instructions off the record, so that it doesn't prejudice anybody or anything. So, yeah. Yes, there is an update. They got a further continuance, and I believe the state's response. The state's opening reply brief is due on February 7th.
All right, guys. It looks like we're having some maybe some sound issues from there. So all I'm hearing is a beeping.
All you're hearing is a beeping. Oh, this guy. All you're hearing is a beeping because the judge just took him to a sidebar, but maybe he didn't catch that. Wouldn't that be nice?
Oh, it's my pleasure to do it, guys. I'm just going to be in and out. I'm doing some stuff. So if somebody out there, if I'm not here and it goes off or something, send me a message. I'll come over. And it looks like they're doing sidebar right now. So they mute that.
Sidebar. Sidebar.
The first motion is the Commonwealth's motion for remedial orders and sanctions. The second is the motion to strike the Commonwealth's motion for remedial orders and sanctions, and a cross motion for sanctions. And in order to show cause why Commonwealth counsel should not be disqualified. I have read everything.
So I didn't get any copies of this. No one told me about this, but it sounds like Bradl filed his own motion for sanctions and to remove Mello. Well, that's interesting. An hour. Oh boy.
So let me first ask you some factual questions. Okay. Number one, can either of you tell me what your understanding is regarding the jail rules? In particular, whether only counsel's calls, counsel being attorneys, calls are unmonitored or also paralegals and investigators?
Your Honor, my understanding.
It's a trick question. It's a trick question. People were talking about this on my Discord. Sidebar. Exactly. So the I already know. Well, it's up in the air still. I already know that we don't know the answer at this point, and I don't think it'll be a $10,000 fine. So no, we don't. So the answer to this is in the rules. Someone posted them in my Discord. I read them. Attorneys have to give their landline number only, not their cell phone number. Landline number only. So can a call to a paralegal be protected under the confidentiality? Absolutely. If the paralegal answers the attorney's landline, typically your paralegals, your investigative teams, your volunteers would all be working at your office. And if the agent, or not the agent, the inmate calls your office as an attorney, that call is protected. And so anybody he talks to at that office, at that number, it'll be confidential because no one's going to be listening in on it to know whether he's talking to an attorney or a paralegal or the secretary who answers the phone or a volunteer or anybody else. So that is the answer to that question.
And I'll preface it by saying I have William Castile from the jail. He's here by way of summons to address that matter. My understanding is it's only attorneys, Your Honor.
Okay, is that your understanding too?
A new attorney could potentially get a settlement. That's what a new attorney can do.
Attorney Bradl?
Your Honor, I didn't have any particular understanding. That's why I was depending on the jail to make the decision for me. And that's why I said who was who and let them decide.
Okay. Second question is, do you have any understanding about the jail rules regarding the length or number of calls that are not to counsel by persons being held in the jail?
I do not, Your Honor. I understand it's a privilege that can be controlled by the jail authorities.
All right. Any different view?
No, Your Honor. I don't know anything about the number of calls.
Is there any court order in this case addressing Mr. Carney's ability to continue to put information out to the public?
Not at this time, Your Honor.
Attorney Bradl?
No, Your Honor.
Okay. Is there anything about what you have?
Actually, Judge, I want to just be very careful. So there's a restraining order matter. That's a civil matter that in paragraph 14 of that matter, the order is, and I'm just paraphrasing it here, but it's just that he not disseminate confidential DCF documents or court documents, I believe it says. So there's something to that effect.
And that is not in relation to this case, but in relation to another case.
Restraining order matter out of Dedham District Court.
All right.
I got to say, so far I like her. As Josh would say, this chick's got balls.
So no court order in this case.
Correct.
All right. So with that sort of factual underpinning, I'll hear from you, Special Prosecutor Mello, and then I'll hear from you, Attorney Bradl.
I'm going to say no, because let me just see if I understand your question right, Paul. If at Carney's trial, the defense tries to introduce statements made between Carney and one of the two volunteers into evidence that were made on these jail calls, no, I don't think they would be privileged because there is a third party that has already destroyed that privilege listening in on it. It would be the same thing as if you talked to if they talked to the client with a sheriff's deputy right there in the room with them. There's no privilege there. That third party has already destroyed the privilege because they did not have a reasonable expectation of that privacy being maintained. Because the jail rules, which are apparently published, because a link to them was posted on my Discord. Let me scroll up a bit. Starman posted it. Starman Returns, I should say. So we're going to share this tab. This is the offender telephone access and use policy and procedure. So it is it is out there. The attorney knew or should have known about them and should have followed them. So, yeah. So I'm going to say that my best guess is that if that arises at trial, privilege would have been destroyed by the communications not being protected or not being allowed to be confidential under the prison jail policy, whatever.
Thank you, Your Honor, I'd like to preface my remarks by saying it gives me no pleasure to be here. In my 40 years of practice, this is the first time I've ever sought sanctions against a fellow attorney. I believe that the actions in this matter, Your Honor, however, are so egregious that it requires action by the court, both with respect to the defendant and with respect to the defendant's counsel. We are seeking, Judge, some limit.
What if, hypothetically, the paralegals were subpoenaed to testify about conversations between Aiden, them, and Bradl at the same time? Well, so this is going to be a where was this conversation sort of thing. If these paralegals, volunteers, were at Bradl's office listening in on a phone call that was protected, i.e. the phone number that Bradl provided, assuming that was a landline, and or that was the number that was registered. I believe according to the policy, it's got to be the number has to be verified by the bar. Well, I don't want to. I don't want to get too far afield. I don't want to get too far afield. It would depend on where the conversation took place. If it was a call to the paralegals on quote paralegals, the volunteers, neither which paralegals. I don't care if one of them has a paralegals is qualifies as a paralegal in a different state. They're in Massachusetts, in a court in Massachusetts. They're not fucking paralegals in Massachusetts. So if the conversation happened on one of the volunteers' phone lines, then regardless of whether Bradl was involved or not, because there is a third party outside of Bradl's team, i.e. the jail, listening in on it, apparently no educational requirements to be a paralegal in Mass. Okay, I heard differently, but I will just take you at your word. Don't really care enough to say.
Limitations on the defendant's communications with the outside world from where he is now. And I understand that the jail can impose those unilaterally if it desires to do so, but we would certainly seek to limit defendant's communications to counsel and defendant's children only.
Why?
Judge, if Your Honor were to review, and I know it's virtually impossible to keep on top of it, the defendant has a number of blogs, websites, etc.
So J5, what should tell you would be a statute. There will be a statute or there'll probably be a statute that governs paralegals specifically because they're so close to their practice of law adjacent. So there's almost certainly going to be some sort of a statute that governs them. So Google's great, but don't always rely on the first thing you Google.
Where he has been actively communicating since his incarceration in the jail.
Well, that's why I asked you at the outset, Counselor, whether there was any court order preventing that particular conduct.
There is not, Judge. However, what has happened is he's communicated, and in this particular instance, that's what brings us here, through individuals, particularly Courtney Haley and Jennifer Altman. He's communicated with them. And my understanding, as attorneys, Judge, in unmonitored phone calls, and I would like to correct one thing. We indicated in our motion, Judge, that there had been some 60 calls to Ms. Altman.
I don't understand Mello's angle here. Mello seems mostly retarded. Kearney's not in trouble in any of this unless Mello actually can get, and it would be impossible to do because it's going to be protected, specifically protected by the attorney-client privilege. But Kearney, he didn't do anything. I mean, his attorney did something. Kearney's not liable for what his attorney did. Kearney's not responsible for what his attorney did. So I don't know what Mello's angle is. I strongly suspect that Mello is a complete fucking retard. He's a fuck up. That would be my best guess.
That is not correct. I apologize. There have been 6 calls to Ms. Altman. My understanding also from talking to the jail authorities, over 80 calls to Ms. Healy, Courtney Healy, who was identified as a paralegal.
Right.
Neither Jennifer Altman
Well, I don't know that he's doing that. To the best of my knowledge, there are 3 in huge air quotes volunteers that this law firm out of New York sent to help him out. So
He's not an attorney. As a matter of fact, Judge, I have text messages here that were copied from the web where Ms. Altman actually posted her text messages back and forth to Attorney Bradl, where it says, I told you twice I'm not an attorney.
oh Jesus, people were posting this. I told you twice I'm not an attorney. People were posting this in my Discord, and I was chastising them that they were retarded, that it's not an admission that he knew at the time that he said it. There's nothing like, she said, I told you twice I was an attorney. Yeah, well, when? When did you tell me? Did you tell me after all of this bullshit came out? When did you tell? Like, and then here comes Mello just trucking along. Fucking Christ. Oh, just incompetence galore.
Attorney Bradl,
All right, so let me pause you again.
I don't have a copy of this.
Okay,
Sorry.
hold on a quick second. Let me pause you again. So what you are telling me,
These are text messages between Bradl and Altman. I don't have copies of these. They're on your phone. Okay. All right. I mean, that salvages Mello a little bit.
is that there were communications with these 2 individuals, neither of whom were attorneys.
Correct.
And that is in violation of the jail rule,
That's correct, Your Honor.
not of any court order.
Not of any court order.
And were they not?
Prove it. Prove it, Jim. Prove it. Even Mello isn't making that allegation, Jim. Fucking prove it.
Identified as attorneys, there would be nothing that would prohibit Mr. Carney from communicating with them
But they would be monitored, Judge.
as a matter of the jail rule.
Correct. And that there's a huge significance there, Judge. Obviously, I'm certain Your Honor is aware, and I'm certain Mr. Bradl is aware as to the purpose of monitoring such calls, particularly in a case such as this. We have a defendant who is now in jail for violating his terms and conditions of release for intimidating witnesses in a murder case. And this particular defendant, let me stop. This case is perhaps the most unusual.
See, you know, if Mello had like slowed his roll a little bit and done a little bit of investigation and actually could show that because of this connection that Carney was using Altman to communicate threats, to intimidate witnesses. If Mello had done his fucking job, Jesus Christ, you're stupid, Jim. Oh, you fucking idiot. Jim, because someone who is not him is writing on his site under his name, well, first of all, you know, Jim, you've read the fucking policies to the blogs. You don't even understand the problem with what you're saying, you idiot. So first of all, you assume without fucking knowledge, Jim, you assume without knowledge that he doesn't have access to the internet. Show me he doesn't have access to the internet. The court was just going over that he has access to the internet and he has access to all these other people. But second of all, do the blogs exist? Do the blogs not exist? The existence of the blogs aren't the issue, you fucking tool bag. So can someone, theoretically, is it possible in a hypothetical situation, is it theoretically possible that someone who is not Turtleboy, who has not communicated with Turtleboy about what specifically to write, but who has access, for example, to his blog, to his sign-in, could someone else who has access to it without direction from Turtleboy write something? Could they? The name calling is wild. The name calling, oh, did I hurt your feelings, buddy? I'm sorry, Jim. You just say stupid shit and you don't understand why it's stupid. So I make sure you know you're stupid. It's messaging and email only. Oh, is that it? So they don't have access to internet? Because I'm pretty sure that if I read the policy right, they have like video calls. They could do video calls. They could do. So I'm assuming that they use some sort of an email app. They could, yes. So see now. So Jim. Oh, so here we go. Yeah. See. You stated something as a fact that was in fact your opinion, and if you had stated it as your opinion, I would never have even stopped to point out how stupid it was. Your opinion is fine. You can have an opinion on it, and that's great. In my opinion, I think Turtleboy is doing bad things because he's a bad person. Great. Awesome, right? But don't say it as a fact. That's where we get down this road of me calling you stupid for saying stupid things. And then when you defend it, like you say it as your opinion, but then you defend it. You see where we get? All right. And then Aaron W., why are you so biased against Turtleboy? What's your issue with him? Well, again, you assume because you're stupid that I'm biased against Turtleboy. I don't think I am. Show me where I've been biased. And I don't have an issue with him. I speak my mind about people. I don't have an issue with him. We have Aiden on the live show. He called in where he says he's going to be more dangerous than ever when he comes out and all threats it. Who the fuck cares? More dangerous than ever? Like, what does it mean? See, you interpret that because Nima, almost anal, is biased. She's biased, so she's going to she's going to interpret everything that he says as bad as possible. So more dangerous than ever. Well, how dangerous was he before he went in? Like, what did he do? He said hurty words. I come off cringe, but I'm the biased guy. All right. So anyway, as EC says, moving on.
Usual that I believe anyone in this room has seen, anyone in this courtroom has seen, with respect to a murder case and respect to bloggers and followers of this blogger, with respect to the public protests, with respect to the internet activity, etc. There are countless. Exactly,
and it fails because he doesn't actually draw that line, or at least my assumption is. You've got it. You can't insinuate things to the court. This gal, no nonsense. She's going to want proof.
There's people who are on Facebook, on YouTube, making videos. Countless people who represent themselves to be bloggers. A number of people on X, formerly Twitter, commenting on this. And this has perhaps generated more communication, if you will, internet and otherwise, than any other case in the Commonwealth, perhaps in the last 25 years or more.
Okay, it is a case with a large public following and a lot of public discourse.
That's correct.
Okay.
Now, with respect to the defendant,
she took everything it took him like 10 minutes to say and boiled it down into a single sentence. That she's so the public's following this case. Great. Moving on.
I believe it's already been established, certainly to a grand jury, and to the satisfaction of the court when his bail was revoked, that he has been harassing a number of witnesses.
That's what he's indicted
in this particular case.
I like her a lot.
The defendant has continued to do so. Just recently, in the past day or so, there was one individual who was the victim in the defendant's last arraignment. Defendant's online saying,
I'm going after Turtleboy. This is Bradl's hearing. I've covered hearings. I've covered filings with the same intensity as that News Now Houston guy. I cover legal things. I cover legal issues, Aaron. And no, I don't think Kate's going to bang me. First of all, she's on the other side of the fucking continent, and I'm married. And in case you hadn't caught this, oh, you dumb shit.
I'm 100% innocent, and she knows I am. He names this individual, and this individual has been the subject of tremendous attacks, if you will, on the internet, attacks to her and her character, etc. Complaints, unfounded complaints of me to DEF, of her, etc. And it's been actually brutal for this individual. And although he was incarcerated or jailed for intimidating her, he nonetheless puts her name out again. And a lot of these communications, we're not sure. We certainly can't know for certain what these unmonitored communications were. If they had been.
We don't know what these unmonitored communications were. Oh my God. So we don't know if they were bad. What the fuck is this guy's problem? Why did he bring the motion? Why did he bring the motion? Now I've read the policy. The sheriff can restrict communications with non-attorneys at their whim. The sheriff can stop protecting these phone calls as soon as they know they're not attorneys. And since the paralegal one was identified as a paralegal one from the get, it most likely was never confidential. So it was most likely being recorded the entire time. Why didn't Mello take his fat, sloppy ass and go and listen to the recordings? Subpoena the recordings, listen to the recordings. Why didn't he do that? Then he would know, and he wouldn't be playing guessing games in a fucking courtroom. This guy.
Been monitored, we would know. We'd be able to examine those as we are all others.
So let me make sure I understand. It's not that you believe that the Commonwealth needs to have access to the content of the communications because it would violate a court order presently in place, but because you have a suspicion that there may be some additional wrongful conduct taking place.
Yes, sir.
You have a did you catch that? It's because you have a suspicion that wrongful conduct may be taking place.
And if I may say, but for the fact
And he's too fucking stupid to catch it.
that these people were on that list, as identified as attorneys and paralegals, neither of which they are, we would be able to certainly monitor the fact that they were placed.
Well, Biv, yes, except in the policy, the specific policy, which let's look it up. Right here, attorney numbers shall be office numbers only and be verified with the bar directory or the investigative unit. I believe the investigative unit would be a division of the jail to investigate issues that inmates raise to confirm before being put online. So attorney phone numbers will be investigated, right? So they can have their access restricted except for attorney calls. All offender telephone calls, except calls to pre-authorized attorney and clergy telephone numbers, are subject to telephone monitoring. So the phone number that Bradl gave for the paralegal would not, in theory, under this, be exempt from the monitoring. These are district attorneys as approved. So there's an approval process. Attorney, or this is capital investigative. I believe they just fat fingered and didn't put unit on there. Telephone numbers will be allowed to be added or deleted at any time, etc. So you get the idea. So
on those lists, raise every type of suspicion we could possibly have as to why the defendant and defendant's counsel didn't want their communications monitored, and that's a major concern of ours.
All right, I understand that argument.
Again, Mr. Bradl indicated he does not have copies of this. I imagine he has copies on his telephone.
Why don't you show him before you read them to me?
I would, Your Honor. Give me a moment, please. I just have a moment, please. Do you have a copy? Oh, they're in the phone.
it is a bit of a dick move, though. If you are going to present something to the court, you need to present it to the other attorney. It was kind of funny the first time when he said it's on your phone, but this is the second time he said it's on your phone. Now, what he is going to hand to the judge may or may not be on Altman's phone. We don't know if, not Altman, Bradl's phone. We don't know if Altman altered the screenshots that she posted. She's not here to testify. So it's a dick move, and I would object if I was Bradl, but Bradl is also apparently not fucking smart enough. I would object, and I'd be like, look, anything you give to the judge, any exhibits you hand to the judge, I get to see because you haven't authenticated any of this shit. You don't know what's on my phone. You're taking something someone posted on X and assuming it's accurate and true. Fucking just incompetence all around. I love it. Now, in these attorneys' in fairness, me from the calm serenity of my living room with my fish tank behind me and the warm and loving comments of my chat to buoy my soul, I'm in a different position than they are in the thick of it, where all the heat was on it. And so, in that stressful situation, you can't always be on it, right? So let's give him a little bit of a break. But be that as it may, dick move by Mello, and Bradl should have been smart enough to object. I don't think you're right, Biv.
You don't have to read them to him.
Well, Mello's motion. This wasn't a preliminary hearing for Mello's motion. I don't know. I haven't read Bradl's, so I can't tell you what Bradl's is. But Mello's motion. He's supposed to have done his fucking homework before he went in here.
Show him the papers. Mr. Bradl can read them. Sorry, you can have a moment.
Wait, did she just say hold on a second.
Show him the papers. Mr. Bradl can read them.
Good. The judge just instructed Mello, his dumb, fat, frumpy ass, to hand the papers to Bradl so that Bradl could read them. I didn't hear Bradl object, but the judge was on the ball. So again, this judge is, as far as I'm concerned, batting 1,000.
Have a moment.
A good question, though, Kate, would be, has there been any hearing that Mello has showed up to prepared to argue?
Is it marked identification confirmed?
It can, Mr. Clerk. Thank you so much.
Yes, it's mandatory. It's mandatory to let the other side see the papers before you present them to the judge. Fucking mandatory.
All right, Attorney Mello, what is it that you want to apprise me of with respect to what's been marked A for ID?
Your Honor, going through those pages, Your Honor will note that the discussion between Ms. Altman and Attorney Bradl, Ms. Altman specifically states that she has told him twice she is not an attorney.
All right, so all of
Objection hearsay. An out-of-court statement presented in court for truth of the matter asserted therein. I'm sure Bradl's going to say it at any section, any point here. There is no opposing party exception because Bradl is not opposing party. The Altman isn't there to authenticate it unless she is there, and I don't know about it.
this goes to whether or not identifying her as an attorney with respect to unmonitored. Calls at the jails was an oversight, was negligent, or was intentional. It all goes to Mr. Bradl's understanding.
The Commonwealth suggests it was intentional, Your Honor.
Okay.
And we do so simply because of the very nature of this whole case, which is somewhat in terms of the system worked up until this, where you have groups of people who have.
So she's saying that it's going to Bradl's understanding, whether it was intentional, negligent, et cetera. I guess culpability for sanctions. Sure. All right. I just wanted to make sure. I just had to think about that for a minute.
Come on board, if you will, to intimidate witnesses and attempt, in essence, to.
But again, those screenshots of texts from Altman don't prove anything. They don't show Bradl's state of mind when he made that phone call and left a voicemail saying that Altman was an attorney.
found the legal system as we have it here. There've already been comments.
I don't think the legal system has been confounded, Mr. Mello.
There were.
Uh,
Your Honor.
All right. Let me ask you this. Is there any information that you're aware of that any of the communications that were publicly made by this defendant during the period that he has been incarcerated in the jail constitute new instances of harassment or intimidation?
We do, Your Honor.
All right. Isn't that a matter for the district attorney's office and the police?
boom! Oh, I like her. Well, I kind of assume in my Discord, I already got a lot of spoilers, and this wasn't one of the spoilers. So yeah, but Jesus Christ. Oh, this judge though, she is just on fire.
It is, Your Honor. However, there's a grand jury is going to be addressed next week on this. Additionally, what our concern is, judges.
Oh boy, more charges apparently coming for Turtleboy. I wonder if that gets Aaron W. What was his name? What was his name? I think it was like Aaron W. Yeah, Aaron W. Does that get your dick hard knowing that more charges are coming, buddy? Or does that make you sad? Do you have a sad?
Is the method in which this was done. If Mr. Bradl is well aware, Judge, of the
So my understanding of this Scorpion Shade is that everyone at the DA's office for this particular county recused themselves. They all said essentially, we have some sort of ties with Turtleboy where we don't believe that we can fairly and we can't be the ones who are bringing this particular cause of action, this particular these charges. So they got. I'm going to guess someone who really needed work bad because he's a shit attorney. I'm not saying he's a shit attorney. This is just how I would guess they arrived at the person they arrived at. They're like, who's the shittiest person possible that we can get and pay the tiny amounts of money that a special prosecutor gets in order to prosecute this case. That's my guess. Because this dude has a lot of years of experience, but he doesn't have much in the way of knowledge of the law, desire to research before going to court, the ability to crack open a fucking law book, the understanding that you probably want to gather the evidence before you bring shit to the court. Basically, Mello's a fuck up, but he's a special prosecutor because all the DAs bowed out. That's, yeah. This is not a complex case, Kate. It's not a complex case. Try construction law if you want complex, where you have like 15 different cross complaints where all the subcontractors are pointing their fingers at everybody else. That gets a little bit. Try a California CEQA case. Those get a little convoluted. They were intimidated. Says the guy who doesn't know. All you know is they recuse themselves. That's it. That's all you know. You don't know why they recuse themselves. All you know is they recuse themselves. So Biff is just like that other guy earlier. Biff is saying shit that he doesn't fucking know a goddamn thing about. Maybe you are an attorney. You don't know. He had a blog on Lally and the other one. So who the fuck cares, Biff? Who the fuck cares? Most attorneys don't care. I don't know what that means. Which one is real dick? And I don't know. He's the one out of 9 people approached, unafraid to go, unafraid. And also because of the shit, a certain lack of reputation, I can relate outside the courtroom. No, it doesn't require a lack of. No. You do your job. You do it right. No. I hate to break this to you, but they probably pay special prosecutors shit. And real attorneys can make a lot of money unless they're unless they're up to their eyeballs in having to do research into a case like this because they've never done it before. He's got a lot of work ahead of him, as any special prosecutor would, and they'd have to do a lot of research. They'd have to put a lot of time in it, and time for an attorney is money. And I'm sure that the other like 9 people had other like 9 practices that made more money than doing this would. That's my guess. Yeah, there's going to be a lot of work put into it. Yeah, and it doesn't pay well enough. It doesn't pay well enough. Oh, Jesus. No one. Yeah, so you've probably actually been in the middle of a few. They're fucking, they're hell. Yep, long balls, nice. Well, you'd think, but anyone with a reputation to protect said reputation. I know. No, you don't. No, you don't. No, you don't. You don't know it for a fact. No, Laura, I will not chill, dude. Blow it out your asshole.
Purpose for attorney phone calls. And I'm going to ask Your Honor to listen to the recording brought by Mr. Castile from the Sheriff's Department.
No, you don't, Kate. You don't know it. You said there's like 9 others. You don't know it because you don't know how many there were. And you don't know if the answers they gave you are correct if you did ask them. You don't know. You're making an assumption.
He's well aware of the reason for this, and it's security, Judge. It's the biggest concern that jail officials have, security both within the institution and with respect to potential victims or witnesses involving the defendant's case. Here, we have a situation, Judge, where Mr. Bradl had been told, I'm not an attorney. He may have a letter from a law office in New York, but that individual is not an attorney in Massachusetts either. When Mr. Bradl says someone is a paralegal, we're assuming, I think it's fair for the jail officials to assume a paralegal in his firm, not someone who he thinks is a paralegal. And Courtney Healy has never had a day's worth of paralegal training, Your Honor. None. And Ms. Altman is not an attorney, Your Honor.
Yes. So when you recuse yourself, you have to recuse yourself for a reason, and that reason is that you have been. So if someone hired me to represent them in a lawsuit, and then it turns out that the other side, the side they're suing, that I have represented before in a particular matter, that I have gained knowledge from them, that I would be tempted to use against them in the current lawsuit, I would have to recuse myself. It's literally because of ties to that other person. That's why you recuse yourself. That's the reason, Laura. You don't recuse yourself because you don't want to take the case. I mean, it's not a matter of I want to take the case. It's a matter of in the process of representing this person normally, in the process of representing them, have I learned something? But it might be something different, and I don't know why, but it is because of ties with Turtleboy. You notice the letter. I don't know what letter you're talking about.
But Mr. Bradl represented both of them to be so. And it is, at the very least...
the letter from the New York law firm was dated 12 days after the jail discovered it? Oh. Well, I don't think that this court is going to sanction him. I mean, the court could, in theory, but I don't think this court is going to sanction him because he didn't do like something to the court. He did something to the jail. But if Mello has 2 fucking brain cells in his head, he will talk to whatever the disciplinary committee is, the disciplinary bar, the whatever. He will talk to them, and they will most likely be like, So, Mr. Bradl, and so you said that it was based on this letter, and then you lied to the judge. We might that it's the state bar that's going to be the real problem, I think, for Bradl.
It's either intentional or at the very least extraordinarily unprofessional for Mr. Bradl to make those representations to court officials
All right,
without
Mr.
confirming them.
All right, Mr. Mello, I understand your position. As you know, the court has broad inherent powers to ensure the fair administration of justice. What I do not have is the power or the authority to sanction an attorney for what appear to be alleged violations of the rules of professional conduct. It seems to me that what you are raising is that Mr. Bradl, intentionally or not, and I will hear from you, Mr. Bradl, violated the rules of the jail, potentially. Correct?
Yes,
and, that,
Your Honor.
and that conduct ostensibly rises to the level of a violation of the rules of professional conduct.
Your Honor, I believe it does.
Ostensibly rises to the level of a violation, potentially. Correct?
Yes, Your Honor.
And that conduct ostensibly rises to the level of a violation of the rules of professional conduct.
Your Honor, I believe it does.
Okay.
But in this particular case, if I may, the court.
What I need you to focus in on is how that conduct has impacted the administration of justice. Because
Let me help you with your argument, Mello. You fucking tool bag. Let me help you with your argument.
what you are seeking are very broad, very
It's unprecedented.
unprecedented orders from this court, and it has to be tied to the court's authority to protect the administration of justice.
Your Honor, when the district court revoked the defendant's bail, the court did so with the full knowledge that the defendant's communications from the jail were going to be monitored. The court obviously found that there was another violation with respect to intimidation of a witness, and the court was satisfied to the degree that the court decided that the defendant should be held at the Norfolk County Jail. Again, the judge in the district.
No. The whatever disciplinary board, if it gets in front of disciplinary board, they might, but not this judge.
District court knew that there would be restrictions on the defendant's communications, that anything the defendant stated other than to his attorneys would be monitored. And our suggestion to Your Honor is that was part and parcel of the reason that the court ordered his bail revoked, because there would be
See, I would bet he does a lot of DUI, and I'll bet he does a lot of family law. DUI and family law is like I don't think he does felony work. I don't think he does anything. I think he knows. I think he's done his little areas of law, and that's kind of what he sticks to. Yeah, well, yeah, but see, the problem is don't make excuses for him. The problem is that if you don't know as an attorney, you're supposed to fucking find out. You're either supposed to do the research to become knowledgeable in it, or associate someone in who has that knowledge. And Mello hasn't done either, and that's a problem.
controls.
Anything said on the record in that regard at the revocation hearing?
Nothing said in that regard directly.
In writing from the court in that regard?
Not specifically in that regard, Your Honor. However,
Anything? Did the court say anything about that? No, Your Honor, but I'm going to make a dumb argument.
it's part and parcel to the whole purpose of holding someone in jail, because very simply, the court was aware that those restrictions would be in place.
All right.
The court didn't make any orders, but the court was aware. Jesus Christ. He advertises as a family and DUI.
So Bradl, obviously being the exception, as the attorney of record, would certainly have direct communications with Mr. Kearney. They would be unmonitored, and that was certainly the standard practice, and counsel would have no objection to that.
All right.
However, in this particular case, these people, both Ms. Altman and Ms. Healy, are well known among the, for lack of a better description, Turtle Rider community.
What evidence do I have of that?
It's the evidence.
What evidence do you have of that? Oh, come on. Yeah. He's not going to have the evidence, is he?
Is all on the internet, and Mr. Bradl.
The evidence is all on the internet. The evidence is all on the internet. God, I thought I was going to be clowning on Bradl. I was kind of looking forward to this because I thought I was going to be clowning on Bradl a little bit. But Mello's the complete fucking retard. The evidence is on the internet, Judge. Well, like, what? Like, where does that work? Where the fuck does that work?
And obviously, I can't bring the entire internet into you. It would be impossible. There's just so much.
You don't have to bring the entire internet. You find a thing where she says, "Hey, I'm doing whatever she's doing for Aiden," and then you print that out and you bring it in and you give a copy to Bradl, you fucking retard, and then you give a copy to the court.
Out there, but
Evidence is usually brought into court and presented to the court.
I understand that, Your Honor.
Oh my God. I need Josh's, that chick's got balls. God damn it. Oh, I fucking hate my life right now. Oh, Jesus. Oh. Oh, yeah. Fabulous. World class.
But what is common knowledge is not necessarily subject to evidence.
I think he's trying to say that the court should take judicial notice of the entire fucking internet or something. I think he's trying to say that judge just go out there and fucking Google it.
And I can tell Your Honor when the sun set today, but I have no evidence of it until the sun sets.
Then it would not be an evidence.
I understand that. But
oh my God. Oh, Jesus Christ. I love this woman. Oh, I love this woman. She married? Would she get involved in a bigamous relationship? Lord, love this woman.
if I may, Your Honor.
Mhm.
The fact is, Attorney Bradl has actively engaged in conversations with Ms. Altman, with Ms. Healy, and he's well aware because of.
Wait, hold on. Did you say Bradl? Bradl? His accusation is Bradl talked to these two volunteers?
The fact is, Attorney Bradl has actively engaged in conversations with Ms. Altman, with Ms. Healy, and he's well aware because of his involvement in this case, just as I am, that these individuals were administrators on the defendant's various blogs, YouTube pages, Facebook pages, whatever. And I think it would be disingenuous for him to say anything other than that.
I'm getting to the point where I almost actively hate Mello.
He's been involved, I'm going to suggest, almost on a full-time basis with this case, in this case only since he filed his notice of appearance.
All right.
And for that particular purpose, he knew who Ms. Altman was. He knew who Ms. Healy was. There's no doubt, and he misrepresented the people who they were not.
Okay. Let me ask you this. Has this information been provided by you or anyone else from the Commonwealth to the sheriff that Ms. Altman and Ms. Healy are not attorneys?
The sheriff's office discovered that themselves, Judge.
Okay.
And discovered that from me when I spoke to them on the phone, and I told them that.
Okay.
That is a serious misstatement.
Okay. And what actions, to your knowledge, has the sheriff taken with that information?
I'm not certain what they're going to be doing with it, Judge. We're waiting for today's hearing.
Well, what are the rules at the jail regarding whether non-attorneys can have conversations with persons held at the jail that are not monitored?
They're absolutely prohibited. Those conversations are absolutely prohibited.
All right. Who is here from the jail?
William Castile?
All right. I think I need to understand two factual things, Attorney Bradl, before we go on, which is it the policy, rules, and procedures of the jail that only communications with attorneys are unmonitored? And I want to know about the limitations on other communications with other persons other than the fact that they are monitored. Length, duration. Okay. Any objection to my taking that evidence?
I don't have an objection.
Meeb. Dude, that's like one of the least funny things that I have been called before.
Merp or whatever his name is. I'm literally watching his stream right now, but I just don't know what his name is.
Well, I don't think I called Mello a scumbag liar. So, correctional officer Cindy, maybe I will see what a scumbag liar Bradl is. Maybe, does he get shown to be a scumbag liar? Oof. I'm only a first-year family law attorney, correctional officer Cindy. I'm just a first-year family law attorney, but you're here watching it. I think Melo's fucking incompetent, bro. I mean, show me where he's been competent. Show me where I shit on Bradl's pleadings. But right now, Cindy. Oh, geez, someone pass Cindy a little bit of Midol. Oh my God, the all caps triggered. Oh, that's awesome.
I just want to invite the court to keep in mind that the issue is what is
That's like a shout out tribute to Jackpot.
my state of mind about what the rules are and what I can do and can't do, and what is disclosed and not disclosed. So,
I understand. There are also requests that I take some action vis-a-vis the jail, and so I want to understand what the rules over there are. Okay. Thank you, officer.
And Judge, just for the record, I had no notice that there was any witnesses being brought in.
I understand.
That there was an evidentiary hearing at all. I think that's extremely unprofessional to ambush me with bringing a witness into the jail that I may have been able to have a conversation with before this.
I appreciate that. I am going to inquire of this witness because I need that factual information. It is not an evidentiary hearing in the sense that it is going to be full-blown inquiry. Okay.
You know, I mean, if you're calling witnesses, it's a fucking evidentiary hearing. I mean, either it is or it isn't an evidentiary hearing. And right now, the judge is calling a witness. I don't know, man. I don't know.
Sir, can you raise your right hand? You solemnly swear the court in the case now hearing to the truth, the whole truth, and nothing but the truth, so help you God? I do.
Sir, can you just state your name for me?
Sure, it's William Castile.
And what is your role at the Norfolk County House of Corrections?
I'm an assistant deputy superintendent.
All right. Can you answer this question for me?
Sure.
What is the policy or rules or procedures at the jail regarding unmonitored phone calls? Are those limited only to attorneys, or does it include paralegals and or?
Yeah, it's just strictly to attorneys.
Strictly attorneys?
Yes.
Okay. So if an attorney identified a paralegal and a person at the jail.
Yeah, absolutely. I mean, I'm just a first-year family law attorney. It's not like I'm right more often than I'm wrong. Correctional officer Cindy, you keep showing me up. You got me good. You got me good.
Jail communicated with that paralegal, they would be monitored conversations.
They would be, yes.
All right. And what limitations are there on non-attorney phone calls at the jail in terms of duration, time, number?
Sure. So it's 30-minute telephone calls.
Mello didn't ask for an evidentiary hearing. In his moving paperwork, he didn't ask for an evidentiary hearing.
And the time, they have tablets now, which they can make.
You couldn't afford to hire me. That's the problem. You couldn't afford to hire me. Correctional officer Cindy. See, what I love about people like you, correctional officer Cindy, is that you try to get authority or respect by calling yourself something like correctional officer Cindy. And it's kind of funny that someone who is so low on the totem pole of respect that they look up and they see correctional officers as something aspirational. I don't know, man. I know. Apparently they are, especially if their correctional officer Cindy mommy is stealing the money from the Girl Scout cookies. Maybe it is family law.
Phone calls, they can e-message, they can receive videos, they can receive photos, and the tablets pretty much all day.
So all day.
10 o'clock at night.
Okay, all day access to the telephone.
Yes.
That is monitored.
Yes.
Okay, and the rule again at the jail is that only communication.
Well, he should have put it in his motion. These twice findings by a judge, which is apparently what you're saying, that there was some highly unethical behavior. I wasn't aware that a judge had found that Bradl was engaged twice in highly unethical behavior, and once that was iffy. But if that is the case, then then Mello should have raised that in his motion, and he did not. So that's a problem.
Communications with attorneys are unmonitored.
Yes, our policy is CSD 482. I have a copy here if you'd like.
No, I will take your testimony. I appreciate it.
You're welcome.
I don't think I'm going to permit any further inquiry because those are just the facts that I needed to understand in connection with these motions. Thank you very much.
I don't like women in power. I was just complimenting the judge. Correctional officers are in power? You're in power? Okay.
All right. Attorney Mello, anything else you want to bring to my attention?
Your Honor, I was going to ask Mr. Castillo, while he's still here, if the court would grant permission for him just to play the recording of Attorney Bradl making this call to the jail, so Your Honor could actually hear it.
But if she's cute, I wouldn't mind doing that for her. I'll squat and cough for her if you're cute, Cindy.
You mean the one that is in your motion?
Yes.
I do not need to hear that.
Okay.
Thank you.
I love this judge.
Thank you, sir. All right. Anything else then?
Well, one other quick is Attorney Bradl made the comment, Judge, that he
You have Mommy Milkers correctional officer, Cindy?
called the jail to take these people off the list. I would ask if that
Made a mischaracterization that I called.
Maybe I missed something there.
that he called the jail to take these people off the list. I would ask if that
Made a mischaracterization that I called to take people off the list. I never did any such thing, Your Honor. I don't know what he's talking about.
Previously, now you correct me if I'm wrong, but previously Mello said that Bradl said that he called and informed the sheriff or whoever, the prison, I don't know where it was, so I'm not going to scroll back to it. But I distinctly remember Bradl saying that he called to tell the jail that these two volunteers were not paralegals or attorneys, and now he's saying that he didn't do it. Or am I missing something?
Quick, as Attorney Bradl made the comment, Judge, that he called the jail to take these people off the list.
I don't remember that he called to take the people off the list, but he called to tell the jail that these people aren't, or at least that the one isn't an attorney. So does that imply that he called to take it off the list? I don't know.
I would ask if that
Made a mischaracterization that I called to take people off the list. I never did any such thing, Your Honor. I don't know what he's talking about.
that is certainly.
Well, never did any such thing. I mean, you kind of did, Bradl. You kind of did say that. You didn't necessarily say it, but you said something kind of like it.
My understanding of what he's.
All right. Both of you take a seat. Both of you. Sir, if you could retake the stand.
My mom is right now in a hospital back in New Jersey. So
Did the folks at the jail learn at some point that Ms. Altman and Ms. Healy were not attorneys?
Yes.
And when did you learn that? Or when did the jail learn it?
what's this tribal thing, J5? I would bet that correctional officer Cindy, since she was hoping that I'd be shitting on Bradl, is actually not a turtle rider.
Around January 11th.
Okay. And has the jail taken steps with respect to phone calls between Mr. Carney and Ms. Altman and Ms. Healy?
Yes, we removed them from.
I hate women in power, except I like this judge. Are you suggesting that I am misgendering this judge, correctional officer Cindy? Are you suggesting that this judge, this female judge right here, is not a woman in power? Like real power, not like a correctional officer, but she has real power. She can affect people's lives, not just inmates.
From the attorney privilege list.
Since January 11th.
Is that racist? Is that a racist term? Are you throwing out racist terms, correctional officer Cindy? I hear correctional officers are often very racist. Is that a little bit of racisms?
11th, yes.
Okay. And how did you come to learn, in particular, that Ms. Altman was not an attorney?
Actually, I received a request from the Norfolk DA's office for Aidan Kearney's call detail log. I sent that over. I scanned it, emailed it, sent it over. A couple hours later, I received a call from one of the troopers stating that I may want to take a look at my attorney.
Well, what so you're not cute, Cindy? Well, that's fine. Then I won't squat and cough for you.
Client privilege telephone call list, in particular to inmate Kearney, or offender Kearney, I should say.
Okay.
And that's what got the ball rolling.
Okay. Thank you.
You're welcome.
Thank you. All right. Attorney Mello, anything?
So it wasn't Bradl. We now know for a fact that it wasn't Bradl who notified the jail that these people weren't. So So now, Cindy, are you okay, Cindy? I just called Bradl a liar. Bradl's a liar. Bradl lied. Bradl said he's the one who informed the jail that these people weren't, in fact, attorneys / whatever. And the guy from the jail came up and testified that that was not the case. Are you happy, Cindy? Are you happy? Like an idiot.
Anything else you want to bring to my attention in connection with your motion?
Other than Your Honor, the fact that it was discovered by the jail in the messages Your Honor has, I believe in that that there's a note that Ms. Altman had told Attorney Bradl twice that she was not an attorney. Mr. Bradl asked the question.
Why are you covering that again? You've already tried to introduce that. It's already been out there. It doesn't say what you needed to say, Mello. It doesn't say what you needed to say.
Did you tell me that before or after I called the jail? Either way, he was aware that and he never called the jail to correct it once he found out.
Sure. Why not?
So I'm going to suggest, Your Honor, that is an attempt to circumvent the authority of the court to have Mr. Carney held in jail under the terms and conditions that the sheriff normally imposes on jail lease.
All right, I appreciate that.
But so Paul, I think maybe Bradl was trying to slice the turd too thin. I think he was just trying to slice the turd too thin. I think he was like, I called him to tell him that I misspoke, but I didn't call him to tell him to take him off the list. That's my guess.
Attorney Bradl.
Thank you very much, Your Honor. With respect to this assertion about,
I'm sorry. Thank you. Thank you, officer.
Judge, with respect to this assertion,
I'm saying you normally shit on women. What, is Aaron W. a woman? Was that first guy, Jim Stroker, or whatever the hell his name was that a woman? And you just got upset because I was shitting on Mello. Are you saying Mello's a woman? Or are you just fucking retarded?
assertion about Ms. Altman. That conversation, those conversations when she told me she wasn't an attorney, we were just discussing who she was, and I was getting.
How's criminal law there, family attorney guy? I'm just a first-year family law attorney. I don't know anything about any of this stuff, except I'm not the one in there getting this all fucked up, am I?
Know her about her role here, and she did tell me at the time that she wasn't an attorney. However, I didn't even remember that I mentioned this call. Now that it's under a microscope, of course, it's out there. But when I spoke with Ms. Altman about those issues, I was confused about.
No. So I've unfortunately done a couple criminal cases, and here's the problem with criminal cases. There's too many criminals. There's too many criminals. I'm not a corrections officer. I don't like hanging out with criminals. And so I prefer not to. I don't like to do criminal law. I'll be honest with you. The law that pays the most money for the least work is like personal injury. The most work is construction law that I've done so far. The most work for the least money is med mal or legal mal. No, legal mal will probably be the most work for the least money. Criminal is just I'm just not a fan of it. I don't like the work. Yeah. But a Karen and Brad divorce, that'd be great. Like a Karen with money and a Brad with money, hell yeah, brother. And I hope they fight just tooth and nail. That's just money.
You know, when did we talk about that? Because I knew I would never have said that to Captain Linsky on the phone if she told me that beforehand. So since then, I have absolutely ascertained that those conversations were weeks later that she wasn't an attorney. She did tell me that, absolutely. But I didn't even remember that I mentioned that to Captain Linsky on that voicemail weeks prior that, oh, she's an attorney, she's a paralegal. So more to the point, Judge, rather than what the jail's policy is, the issue here is what was the interactions? And all this is laid out in my affidavit, Judge, and in my motion. And that's exactly what happened. There's nothing here but an honest mistake.
So does the court have power to sanction? Yes. Is the court going to exercise that power to sanction? My guess would be no. Does the court have the power to appoint a special master, essentially, to listen in on all of Aiden's calls to Bradl? I don't know. I honestly don't know. That's a harder question. I would, because your right to counsel, I mean, that's enshrined in the Constitution. There might be something enshrined in the Massachusetts Constitution. So I think that Mel would be on a lot, or the judge would be on a lot thinner ice doing that than even a small sanction. I don't see a sanction I know she took it under advisement. I don't see a sanction, at least not at this point. Not unless Mello pulls some magic out of his ass. And I don't see a special master. And I think the court is going to leave it with, well, he can call whoever he wants to from jail. But as long as the jail has its own rules, and so the jail gets to listen in on his conversations to not any phone number but the phone number supplied for his attorney.
I was, at the time, I got 3 folks from the civil side of this thing where Ms. Dombrowski, and you have her letter there.
You thinking about my schlong? Nice. How you doing, Cindy? It's Friday night. How you doing?
He's working on the First Amendment aspects of this case, and the First Amendment aspects of this case were starting to arise, Your Honor. And so Mr. Carney arranged and Ms. Dombrowski arranged that I have 3 people to help me with the First Amendment issues.
Wait,
And
what? So, so Bradl has 3 non-attorneys come in to help him with First Amendment issues. So what he's going to have non-attorneys do the legal research required to figure out if why as an attorney would you get 3 non-attorney volunteers to do that kind of legal research?
after that, Mr. Carney got incarcerated on the bail revocation, and we had all been speaking, and they all speak with Mr. Carney. And so I'm not 100% familiar with the rules about.
It looks like she has a very nice ass, but I have never kissed De Laguna's ass. I was nice to her. You could be nice to people. You don't have to be a dick all the time. You can be nice to people. I know you're like, who are you to say this, John? Well, you could be nice to people.
Attorneys or paralegals or investigators or who's allowed and who's not.
Well, we all now know, only attorneys.
Yeah, you're right. Certainly now we know. But at the time, my practice would be to just make.
I did look it up, and Mello is a family law and DUI guy. Yeah, that's what he advertises: family law and DUI.
Make sure my phone numbers are on the list, and you have the voicemail there that shows that I clearly stated that this one's a paralegal, this one's an attorney, and I was just mistaken about that she was an attorney. And I think
I was just mistaken. Like Bradl's in a bad position here. Bradl's either I'm incompetent or I'm a liar. And right now he's got to basically throw his hat in front of the court to say I'm incompetent. It's not a good position.
I might have just conflated that or something, but it was just an honest statement.
I mistake volunteers for attorneys all the time, right? So yeah, the jail is, quote, partially to blame, end quote, because the jail has a set of policies in place where attorneys' phone numbers have to be the Massachusetts bar approved attorney number. Attorney numbers shall be office numbers only and verified with the bar directory. So yes, the jail fucked up, but the jail didn't. I mean, the jail isn't the one in front of the court. The jail doesn't have a responsibility to the court on this. It's a violation of jail policy. So someone might get their hand slapped, but that's it.
I've ever worked with on this case. And, I just don't understand why or where Mr. Mello can stand up in front of the court and make a statement that Ms. Healy, for example, has never had any paralegal training. Like, are we going to really go into the issue of what the training is of these folks? I mean, Ms. Healy has taken college classes, just because he raised it. Ms. Healy's taking college classes for criminal justice, and she's amazing, and she's a terrific paralegal.
She's taking college classes, so I'm going to use her to do First Amendment research because.
In fact, I'm going to be hiring her for some of my CPCS murder cases to work as a paralegal.
I'm going to be hiring her in the future.
There we go.
Okay.
And I've actually got the ball rolling on that.
I think we're afield.
I'm sorry?
We're getting a
Okay.
little far afield.
Yeah, so I'm just trying to respond to the things that he raised, Your Honor. I'm
You don't
sorry.
need to respond to everything that he raised.
Okay.
I read your papers. I understand your position, which is that it was an error on your part, that it was not intentional.
There was an absolute oversight, Your Honor. And at the time, I didn't know whether
No, if you're cute. I thought you said you weren't cute, so I'm gonna pass correctional officer Cindy.
the fine points of their policy, whether it meant just lawyers or paralegals and investigators. And so in that situation, you just do full disclosure. I said to them, Captain Linsky was very professional and helpful. And they said, here's the people that are on our legal team. And a previous call, I believe I said it was Mark Tippett, our investigator, and Mr. Dombrowski, the other lead counsel on the civil issues. And then on this call that's in counsel's filing, I said very clearly, Courtney Healy, paralegal, and again, dissolve my touch as well. So I was not trying to deceive or hide anyone's status from anyone. I was putting it on the jail to do whatever they were going to do. And so I received a message, and that's in my affidavit, Your Honor, the next day, that everybody was on the list. And I thought that was great, and that we were going to be able to strategize and
All right. I understand your position, Mr. Bradl. Attorney Mello, the first request that you have of me in your motion is that the Norfolk County Sheriff be ordered to revoke the defendant's privilege of communicating with parties other than his counsel of record. Given the testimony that I have heard today, you want to stop his ability to use the tablet or the telephone in all respects.
other than his children and Attorney Bradl. Yes, Your Honor.
And what power do I have to do that?
Your Honor,
Order the Sheriff's Department to limit his telephone privileges entirely.
the inherent authority of the court allows that, Your Honor. The court can
The inherent authority allows the court to revoke Aiden's privileges to talk to other people because Aiden's attorney did a boo-boo. That's a novel argument.
certainly issue that restriction.
But I thought your point was those would be monitored. All communications other than with counsel of record would be monitored.
They would be, Your Honor. However, what's come out thus far has certainly been harassing to some of the individuals. As I indicated, the victim who, the last arrest that put Mr. Kearney in.
Well, now we're talking. Nice. I mean, with a ball gag in, you don't have to be good looking, right?
The jail just online this week indicating, this victim knows I'm innocent. And there have been a number of other elements of harassment. Mind you, this is the same defendant judge that has openly acknowledged in court that he wanted the opportunity to post BCF records about this particular victim in order to humiliate him for no other purpose. So
Mello keeps getting off topic. The topic here is, what did Bradl do? Well, I don't know why he's talking about Aiden.
he's still engaged in his campaign, if you will, of harassment and intimidation. And the original order was that came up from the district court in Stoughton. All those cases are now no pros. The purpose of the order was to stop him from directly or indirectly attempting to intimidate people. He's behind bars, Your Honor. He's just as active as he was when he was in public.
But that's why I asked you at the outset. There is no order like that in this case now.
No.
Okay. Anything else then before I take this under advisement, Attorney Mello?
Your Honor, we do have the last, and this is an abundance of caution. I know it's unprecedented. We have paint teams being established in this matter for various telephones and electronic devices that have been taken. Obviously, Your Honor, the purpose of a paint team is to prevent the Commonwealth from viewing anything that would be considered to be attorney-client or otherwise prohibited to the Commonwealth that's on these devices. One of our concerns, Judge, with that respect is that we need, and this is what's unprecedented, the Commonwealth feels it needs a paint team of sorts that works in the present time. We are so concerned about Mr. Bradl's actual intentions. And the Commonwealth, I apologize, Your Honor, the Commonwealth does not concur with Mr. Bradl's position that it was an accident or an error. Certainly, that's something that at the very least should have been confirmed. So, again, the Commonwealth does not concur that it was an accident. Nonetheless, given the fact that Mr. Bradl made such a move, if you will, to have non-attorneys listed as attorneys, we're concerned that Mr. Bradl's motives may be to play up to the defendant's desire for this publicity that he has. And that if attorney communications with the defendant were unmonitored, Mr. Bradl could use those communications as an opportunity for third parties to be involved, to simply engage in the same types of unmonitored conversations that the jail's rules are intended to prohibit.
I don't know what you are inferring, that Mr. Bradl would put someone else on the phone?
Yes. That's a concern the Commonwealth has, Judge.
All right, so you are asking me to appoint somebody to monitor all communications between the defendant and his counsel in this case.
And only report to the court, and not to the Commonwealth, Judge.
And under what authority do you make that request? Or is this entirely an unprecedented request?
Highly unprecedented, Your Honor.
All right. Thank you. I understand.
Entirely unprecedented.
I'm completely shocked.
What authority do you have? Fucking none. Oh my God! What authority? Whatever you got, Your Honor.
Okay, we don't need to start with.
And the idea that I'm doing something wrong is just so completely offensive to me. I can't even fathom, Your Honor.
Let's focus on my power and authority to do what the Commonwealth is asking me to do.
There's no power to do that, Judge, but I just can't sit here and have counsel level these charges against me without responding. I would never do anything of the sort. I never have done anything of the sort, and there's nothing but complete, utter speculation with respect to what he's saying. That
I don't know. I kind of wondered about that too. I just think it's a Massachusetts thing. In California, the attorneys sit, at attorney tables to the left, one to the left, one to the right. Plaintiff or petitioner will sit on the side closest to the jury. I don't know. I don't know what this is. I don't know why one's sitting so far in front of the other.
they're worried that I'm going to do something with the calls.
All right, Mr. Bradl, are you the only counsel of record for Mr. Carney in this case?
Yes, Your Honor.
Does he have other counsel in connection with other pending criminal matters?
No, Your Honor.
You are his only lawyer?
Yes.
All right. So I'm going to take this all under advisement.
Yes, I strongly suspect that Mello is just hoping the judge will carry him, that the judge will provide an order and supply the law for it, which, like, it's a family law tactic. In family law, you don't have to argue the fact. Well, at least in California, family law, you argue the facts. You don't have to bring any law, and he's arguing like a family law attorney.
But I am going to direct you today to send a written communication to the Norfolk County Sheriff's Office indicating that you are the only attorney of record for Mr. Carney, and then file with the court an indication that you did so. All right.
Actually, Judge, now that I say that, there may be another attorney who is on the list, Attorney Randazzo. I don't know if he made the list or not, but he's another attorney who speaks with Mr. Carney about First Amendment matters and advises him as well.
And where is he barred?
In Massachusetts, Your Honor.
He's a Massachusetts barred attorney. So
I have to look into it. I don't know. I'm just trying to be absolutely careful about everything that I say.
no, I want counsel of record in his criminal matters.
Okay, just
so if Mr. or Attorney Randazzo,
Mark Randazza.
if he
So there's another attorney who's going to be doing. Hold on a second.
so
I have to look into it. I don't know. I'm just trying to be absolutely careful about everything that I say. There may be another attorney who is on the list, Attorney Randazzo. I don't know if he made the list or not, but he's another attorney who speaks with Mr. Carney about First Amendment matters and advises him as well.
and where is he barred?
In Massachusetts, Your Honor.
He's a Massachusetts barred attorney. So
I have to look into it. I don't know. I'm just trying to be absolutely careful about everything that I say.
no, I want counsel of record in his criminal matters.
Okay, just
So if Mr. Or Attorney Randazzo,
Mark Randazza.
if he wishes to be on that list at the Norfolk County jail, he'll have to enter an appearance in this case. So you are to communicate with the jail that you are the only attorney of record.
That's fair. That's fair. Like maybe working on maybe First Amendment issues. Like I don't understand. Like I don't understand what's going on here. Aiden seems like he has a lot of attorneys doing a lot of things that haven't actually turned into anything. So I don't know exactly what's going on here, but it's a little weird.
For Mr. Carney, and report to the court that you've done so. Okay.
Yes, Your Honor.
By the end of Monday.
Sure.
By the end of today, actually.
Okay.
Okay. All of the other requests that the Commonwealth is seeking, I will take under advisement, unless there's anything else you want me to understand.
Judge, there's quite a bit more in my motion that I want to bring before the court.
Okay.
With respect to Ms. Altman, Your Honor, I've only spoken to her a couple of times, and she was presented to me at the time as part of this team, and I let it.
I'll check that out later.
I let it.
I'm running out of time.
I gave it to the jail about who was what, and what they were going to do was up to them. I'm not responsible for their jail policies. I'm responsible for my client, and I wasn't sure whether people on the team could have those calls or not. So that's why I left it to the jail, and it's all on the voicemail, and there's nothing that was hidden or deceptive about it whatsoever. And after all this came to light, Your Honor, keep in mind, I never knew anything about Ms. Altman being called. I never knew anything about anything until counsel filed this motion.
Well, I guess it depends on if you're stronger than me or not, Cindy.
And which leads me to my next point, Your Honor, that I want to ask the court to strike the pleading.
No, Alex, she was presented to him as part of his team. He doesn't even get to pick his team, apparently.
Pleading absolutely does not comply with the rules, and it does not have any affidavit, and there's no swearing whatsoever to it. And it was, again, continued here in court where counsel's making these speculative, insane, unsubstantiated allegations about me and about Mr. Carney and everything else.
I already said I'm gay, Cindy. dummy.
Counsel likes to say,
Are you gonna mock me? Are you gonna call me gay? Is that gonna be your insult? You gonna call me gay, Cindy?
what I'm aware of, Your Honor, okay? I'd like to tell the court what I'm aware of and what I'm not aware of. I had never met Ms. Altman at the time of this, of giving her name to the jail. And the conversations about when she talked to me about what she did and who she was, about her not being an attorney, were much later. And again, I did not equate those conversations.
But again, either you're incompetent or you're a liar.
With anything that I said to the jail in passing on a voicemail to Captain Linsky.
No, you don't love your gays because you're about to use it as an insult. You're about to say, "Oh, are you a top or bottom because you're gay?" Oh, you're bottom. Oh, I love my gays. You're a liar. See, you're a liar. You're a terrible person and a liar. How about that?
So, counsel files this motion, Your Honor, and publishes all of the phone numbers, all the private cell phone numbers of myself, Ms. Healy, and Ms. Altman. And as you can see in the
yeah, I remember that too. And I was telling him to shut the fuck up. But did he? No, he did not. No, he was the one who's just too smart, and I was dumb, and I was wrong for telling him he should shut the fuck up. But
motion, Judge, as a result of counsel for the Commonwealth doxing all of us in this public filing.
Yeah, this is pretty fucking stupid. Bradl's fucking retarded. Bradl's like, I got caught either lying or being completely fucking incompetent. I'm the one who put out these people's names and phone numbers. And now the state, because Mello's the fucking state at this point. Now the state is using what I did against me and seeking sanctions against me because I violated jail rules. And so I'm going to say that he doxed my volunteer. This is fucking stupid. Like, why are they wasting the court's time? Like, this reminds me of two family law attorneys going at it.
Ms. Altman receives threatening text messages that absolutely scare the heck out of her and terrorize her, Your Honor. And
no, you wouldn't. You wouldn't. You're not strong enough. You get an ass full of cock.
In that respect, Your Honor, she is absolutely scared and horrified and intimidated. And I've spoken to her personally about that. And she has a copy of all my filings, Your Honor. And here we have the situation, Judge, where in the course of trying to say that I'm doing something wrong, counsel publishes these phone numbers and absolutely exposes Ms. Altman.
You were doing something wrong. Either you were incompetent or you're a liar. Either way, you did something wrong, you dumb shit.
And Ms. Healy and myself to unwanted harassment. And in this case, in fact, as I published in the filing, Ms. Altman did receive that very night.
Published in the filing. So Mello is currently protected by the prosecutors, by prosecutorial immunity. And there's probably also litigation immunity, at least there is in California.
A number of obnoxious, threatening, harassing messages. And I published one of them for you so you can see what she was dealing with. And this is from...
Well, see, if Bradl had known jail policy and have followed jail policy, then all he would have given was his landline to his office, which is probably published somewhere. Jesus.
Counsel for the Commonwealth. Lawyers have obligations, Your Honor.
Apparently.
Lawyers have obligations to not dox people, first of all, Your Honor, to not publish sensitive private information in pleadings. That was done here. And that is outrageous and that is unprofessional.
Are you asking me to seal? I know it's out in the public realm somewhat now, but are you asking me to do anything in connection with the Commonwealth motion?
Yes, I would ask you, whatever we can do now is to seal it for now, so that at least it's from now on it's sealed and the private information is not public.
All right.
Or at least that portion of it.
Any objection to that, Attorney Mello?
I would just ask that the numbers be redacted.
Well, we will impound.
But so going back to Kate's point, like if it's so terrible, right? If it's so terrible that names and phone numbers get put out there, and if that is grounds for sanctions, what did Aiden do? Didn't Aiden put names and phone numbers out there? Right?
What has been filed, and if you would provide a copy with the numbers redacted, that can go on the public docket.
Thank you.
I find good cause to do so. Attorney Bradl, anything else?
Yes, Your Honor. In this case, Your Honor, Counsel for the Commonwealth has charged Mr. Carney with the exact same conduct, categorically, as he has done here to me, to Ms. Healy, and to Ms. Altman. For the Commonwealth has charged Mr. Carney with the exact same conduct, categorically, as he has done here to me, to Ms. Healy, and to Ms. Altman.
So now Bradl is suggesting that it is witness intimidation for the state to bring a motion for sanctions against an attorney for violating jail policy. Well, I can't wait to hear how he argues this one.
The results actually happening to Ms. Altman, unfortunately. I'm not going to go over the factual underpinnings of it, Judge. It's in my motion. But the same exact conduct is charged to Mr. Carney, where he's alleged to have held up a piece of paper on his YouTube show.
Aiden's in the house because it's on his case. So because it's on Aiden's case, it involves Aiden. And so Aiden has a right to be there.
With phone numbers on it, and then called phone numbers, and then mentioned phone numbers on the show. And then that was to one of the troopers on the underlying Karen Reed murder case, Your Honor. And then the charging documents indicate, Your Honor, that Mr. Proctor, the trooper involved, received threatening messages, et cetera, et cetera. And that was the basis in the Stoughton court for a charge of witness intimidation on Mr. Carney. And here, counsel for the Commonwealth has engaged in the exact same behavior.
But see, the defining characteristic is that it has to be done to a witness with the intent to get them to alter their testimony. Is this lost on Bradl? Are the elements of the fucking crime his client has been charged with lost on Bradl? Does Bradl not understand the fucking elements of the crime that Kearney is charged with? That would be concerning to me as Kearney if my fucking defense attorney didn't understand the elements of the crime that I was being charged with.
With the exact same results that Ms. Altman has received threatening messages.
And that's the basis of your request that I issue an order to show cause regarding recusal.
That's correct, Your Honor.
All right.
Counsel now has a personal stake in this case because counsel's categorically committed the exact same conduct that he's charging my client with.
Oh, God, I can't handle this. But, mad fucking props to the judge. She has not laughed in either one of their stupid fucking faces. I respect her. Because these two fucking incompetent imbeciles, that's why I can't be a judge, because I'd be like, shut the fuck up, you goddamn idiot. Like, stop talking, you're retarded. Oh, she's just calmly taking notes. Like, maybe you're trying to say this. It's not going to help you, but cool. Did you want to address any elements? Provide any authority? Anything? No, okay, we're good. Okay, all right. Oh, Jesus.
It's just talk about unprecedented. Mr. Miller likes to talk about what's unprecedented. What's unprecedented
is accusing the state of witness intimidation when the state isn't intimidating a witness.
That the prosecutor is engaging in the same criminal conduct that Mr. Carney is alleged to have engaged.
Oh! I don't want to be here anymore.
Yeah. Counsel for the Commonwealth now has developed a personal stake in this case. Counsel for the Commonwealth is not a disinterested observer, an advocate for the Commonwealth interested in doing justice. Counsel for the Commonwealth has inserted themselves, has wrapped themselves in personally into the allegations in the case.
All right, I understand your argument.
So based on that, Judge, I think
she's like, I understand your argument. Shut up, stop talking. I get it. This isn't going anywhere.
I'm not asking right this minute that he be disqualified, but I'm asking that you issue an order to show cause and set up a hearing as to why counsel for the Commonwealth should not be disqualified in this case.
Attorney Mello, how much time do you need to respond?
Mel is not getting disqualified. Mel is not getting disqualified for bringing this motion. Oh,
to that request?
Which one in particular,
The
Judge?
request that I issue an order to show cause regarding recusal.
I believe that Mr. Bradl has put 14 days in his motion. I believe he requested the match within 14 days. Is that after the 14 days, Judge? And if I may, Judge, there's a huge distinction.
Well, wait a minute. So you're saying you will file something in response by February 9?
Yes, please.
All right. When I receive that, I'll make a determination about whether I issue an order to show cause and whether we have an evidentiary hearing.
If I may, Your Honor, the distinction that Mr. Bradl, between the fact and what Mr. Bradl is saying.
So, Paul, I think so. As Cindy has very accurately pointed out, I am just a family law attorney, and I don't understand the highfalutin arguments that these big-time criminal attorneys make. But yeah, I thought it was a little bit different, but
Mr. Bradl is indicating this was doxed. The reality is the telephone numbers here were absolutely relevant to this matter. This wasn't a gratuitous publication of telephone numbers of individuals. This is a publication to the court. This was a filing with the court. It was not an outside filing. It was not a press release, whatever. It's a filing with the court of the numbers that Mr. Bradl indicated were attorney numbers.
That's a lie, Your Honor. I did not indicate they were attorney numbers.
Don't interrupt. I've read what you indicated. Go ahead.
And Mr. Bradl indicated they were attorney and paralegal numbers, Your Honor. He published that to the jail. Okay? As a matter of our motion, that was absolutely relevant and part of our motion.
don't tell coded.
Had it been a different number, whatever the be, motion, they were very relevant. And the motion could not have flown otherwise, Judge.
All right.
But so that's not a bad argument by Mello. That's not a bad argument by Mello. I had to show the numbers because if he had actually given numbers to, say, a actual attorney and misstated the names, then but now we have two corroborating bits of evidence. We have the telephone number and the name, and so we know for certain, based on both, that neither one of them is going to the landline of an attorney. So, not a bad argument, Mello.
Appreciate everybody's
Not
arguments.
great.
I understand everybody's arguments. Let me tell you how I have endorsed what is in front of me at the moment. The Commonwealth's motion for remedial orders and sanctions has two endorsements. Number one, counsel for Mr. Carney is to inform Norfolk County Jail by the end of day today that he is the only attorney of record for Mr. Carney at this time, and report to the court in writing by close of business Monday, January 29th, that he has done so. Second order on the motion for remedial orders and sanctions. Upon oral request for good cause, paper 4, the Commonwealth's motion is impounded. Counsel for the Commonwealth to file a redacted copy for the public file. Mr. Bradl's cross motion is endorsed Commonwealth to respond to cross motion on or before February 9, 2024. With respect to the Commonwealth's other requests for relief in the motion for remedial orders and sanctions, I will take those under advisement.
Thank you, Your Honor.
Under advisement means that she's going to go back and have herself and or a law clerk go through them and figure out if there is any merit to them, since Mello is too fucking lazy and incompetent to do it himself. My best guess, and remember, I don't practice law in Massachusetts, and I'm not doing any research on this particular motion. I just expect the sanctions to probably be no sanctions, and I expect the court not to allow a special master to listen in on the attorney-client phone calls between Aiden and Bradl, or more correctly, between Aiden and Bradl's office. I don't think it will restrict if Bradl is in fact thinking of hiring these volunteers as paralegals. If that is the case, then it will not restrict Aiden from having confidential conversations with them. And Mello's not going to get recused. The interesting thing is going to come about if Mello isn't completely incompetent and Mello has reported this to the whatever committee or board or what have you reviews attorney violations of the rules of professional conduct. So catch up a little bit. I actually didn't pay any attention to him, so I'm glad you only have eyes for him. I guess his dick made a permanent mark on you. Well, so far there's been no allegations that she's done anything. If she does catch charges, I would assume it would be something related to witness intimidation. And were you catching them, Kate? Were you catching the kisses? Mm-hmm, mm-hmm. Mm-hmm. Don't Project Constitution. Don't talk about his jerk off vids. That's disgusting. I've never seen the full unedited one, and I don't want to. But yeah, I've seen enough in a GIF to know I never want to see it again. Mm-hmm. Mm-hmm. All right. One other thing that I did want to talk about real quick, and it was in Springer. So if you're here for more Turtleboy nonsense, this is just a Springer thing that I found incredibly fucking hilarious. Shit, it's down instead. So in this particular district, you have to ask the other side before you file something, motion or something like that, if they're going to oppose it or not. And I think it was this one. Yeah. This is fucking hilarious. So the plaintiff is trying to, they file a motion to for leave to file a surreply. A surreply, normally there's the motion, opposition, the reply, and then the opposing party has to request leave of the court to file a surreply. So blah, blah, blah. It appears that notions of fair play and due process in litigation as murky to the upset defendants, again, not spell checked at all or proofread at all, to the upset defendants as understanding the rights of citizens to criticize their elected officials under the First Amendment and under the New Mexico Bill of Rights. Nearly the entirety of the defendant's reply, doc number 89, consists of new argument relying on new evidence not contained in the motion. It is incumbent that plaintiff should be given the opportunity to address this new argument and new purported evidence, especially in light of the fact that the motion was filed as Rule 12B motion, but seeks to have this court review evidence not contained in the filing. It was in the alternative as a summary judgment. Plaintiff's counsel did endeavor to comply with Local Rule 7.1 to discern whether or not the defendants opposes proof, but defendants refused to provide a position of opposed or unopposed on the motion and should be deemed to have opposed the relief requested herein. See Exhibit 1 here too. Well, let's look at Exhibit 1 here too, right? Because he just doesn't know whether or not it's opposed or unopposed. So your clarification is you're not providing clarified position? Because she says, good morning. To clarify my response, defendants take no position and will defer to the court regarding your request for relief. He doesn't understand it. So your clarification is not providing a clarified position? Because I need your position on a motion. This is just really for Springer's edification. Stop shouting this. Sorry, my apologies. If you ask opposing counsel if they are opposing or not opposing a motion, and they say, we'll wait to see what the court says, that means that they're opposing it. That literally means they're opposing it. Because if it was unopposed, they wouldn't have to wait to see what the court says. I don't know why this was hard for him to understand. All right. Not even like that, Merb. Yeah. You've had the turtle head poke out. I have personal feelings. It's just surreal from every angle. Sure. Well, I mean, one man's hero is another man's villain. If Merb could fuck Kate, then the world would also become sane, aka never going to happen. Well, thanks for letting me know that it was never going to happen. What with me being gay and all. Cindy's a psychic. Is Turtle trying to throw a gang sign? I think he's adjusting his glasses. Some people worship bullies and assholes. I think it's aspirational, sure. All these attorneys seem like a bunch of fools. They do. That's very true. It shows lawsuit against food bacon still going on. Yeah, I haven't read anything. Apparently, there were a whole bunch of things filed or posted in Discord lately. Stop shouting, messes up the audio. My apologies. Blue Bacon went on the offensive and filed a bunch of new motions today. Motions don't win it. Motions don't win it. Merb is getting hard. Ooh, am I? Let me check. Hand me the lube. Ooh. Well, if you need lube, then you're not ready. Finish him. Motions to compel discovery. Ooh, that'll be fun. That'll be fun. Too bad we probably won't get to see the discovery, though. I thought the trainer could have been dismissed by now. Nope. At least Burp doesn't have his cock out tonight. How do you know? How do you know, sir and or madam? It soon will. It will be soon. Please do not bring me into your crusade, Cindy. Which show has your? I'm assuming me and Turtleboy boned this morning. Love. Okay. Good for you. If you're into goats or sheep, is that gay? Well, if they're the same sex, maybe. I don't know. This feels hurt. And all right, so we've reached the end. Thanks for watching, and have a great weekend.